In the previous lesson, we introduced the subject of human rights, specifically within the system of the United Kingdom. We noted that there is a certain importance that we have to address with reference to the UK's constitutional framework, and talk about how this is actually quite distinct from a number of other constitutions and frameworks that exist around the world. And so, as a result of which, we are able then to understand how human rights operates within the United Kingdom more generally. This lesson is going to talk about how this actually operates from a historical perspective, talk about some of the major historical developments in human rights law from the United Kingdom, or from England and Wales into the United Kingdom, which we eventually get to. So, ultimately, the previous lesson, we introduced the subject of human rights within the context of the UK, and we're going to talk about the historical development. Now, we're going to talk about the historical development in a quite brief manner in this lesson, because ultimately, the historical development of human rights in throughout the history of England and Wales, all the way through into the history of the United Kingdom, is very long. There are lots of different processes, there's lots of different complexities that exist, but there are a couple of major points where we see the development of human rights. And we can sort of divide this, at least in the sort of lens and the kind of resolution that we are looking at it, we're going to divide this into four major aspects, four major points, okay? We're going to begin by talking about Magna Carta. So, ultimately, we know that the UK operates as an uncodified constitutional setting, and we know that there are various different sources of constitutional law which are derived from various different documentation and different places. Ultimately, the two most historical, or at least the two of quite significant historical importance when it comes to constitutional law and the nature which pertains to the protection of individuals and human rights, relates to Magna Carta and the Bill of Rights. Now, it's a little bit misleading to suggest that these relate to human rights, because when we think about human rights, we tend to think about human rights in the context of a certain collection of characteristics which every single human being has access to, essentially. So things like the right to life, the right to education, the freedom of religion. That's not what the Bill of Rights did. That's not what Magna Carta did. They were a little bit different, and we'll explain why in this lesson. So, ultimately, potentially one of the most important historical documents ever written was that of Magna Carta. Now, there is often an overemphasis placed on the importance of Magna Carta today, but at least in 1215, Magna Carta represented quite a significant step, specifically in the relationship between the king at the time, King John, and his barons. Ultimately, like I've just mentioned, it born out of a dispute between the King of England, who was King John, and a number of his barons. The agreement led to the creation of certain rights and protections for subjects, such as basic principles of trial by jury and the idea of habeas corpus. Ultimately, King John was forced to agree to Magna Carta, and Magna Carta would eventually then be translated into into subsequent documents, which would then also be agreed upon by subsequent monarchs. It would also have made a number of major changes, so a number of provisions of Magna Carta were then taken out and then some added in, etc., etc. Arguably, it is one of the most important historical documents when it comes to the idea of human rights, but it doesn't protect human rights in the same way as a human rights document does today. Of course, it was very heavily influenced, or influenced a number of interesting documents such as the US Bill of Rights, for example, certain ideas pertaining to the Enlightenment and stuff like that. But like I've said, in terms of it protecting human rights, in recognizing that every single person who lives under the King of England has certain inalienable characteristics and rights which cannot be trampled on, is not what Magna Carta did. It more regulated the relationship between King John and his barons being, of course, very high members of noble classes. So the idea that this was a human rights document in the kind of modern strict sense is a little bit misleading. It's not a human rights document like the US Bill of Rights was. Nor too was the Bill of Rights of 1689. The Bill of Rights of 1689 came out of one of the most contentious periods within English history, the English Civil Wars, and the challenge to monarchical authority that came with it under the Stuart dynasty, or at least under the early period of the Stuart dynasty. It formed part of the settlement between the Crown and between Parliament. And ultimately what the Bill of Rights did was essentially make a very strong step towards fundamental rights, but specifically made a strong step towards the fundamental relationship between Parliament and the Crown. So in a similar sense that Magna Carta codified the relationship between the barons of King John and the monarch himself, the Bill of Rights of 1689 tried to regulate the newly invited monarch, William of Orange, back into England, but with restrictions on his authority and on his power, making it very clear, for example, that when it comes to certain competences pertaining to things like lawmaking, the Crown was subordinate to Parliament. That's what the Bill of Rights tells us. So again, it's not the same as the Bill of Rights like we see 100 years later with the Bill of Rights in the United States, because it doesn't really make much of a dent in the conversations that we have relating to the fundamental rights of every single human being and the kind of philosophical foundations pertaining to the concept of human rights. Skipping ahead then, we will get on to looking at some developments in history as well through the common law in the next lesson, but skipping ahead then to some more modern human rights documents. Of course, the majority of the human rights that we will look at today will be in reference to two major events which takes place. The first major event is the entering of the United Kingdom, or the partly forming of by the United Kingdom, of the European Convention on Human Rights, which takes place in the late 40s, early 50s. The United Kingdom was a founding member of the Council of Europe and was very much influencing the contributions and was one of the founding creators of the ECHR. Famously, Winston Churchill contributed significantly to the creation of the European Convention on Human Rights. And we have remained a member of the European Convention on Human Rights and the Council of Europe ever since. And we, at least at the time of recording this lesson on the 13th of October 2023, we continue to maintain our commitment to and our relationship with the Council of Europe and a membership to the European Court of Human Rights. But one of the things that happens when we talk about the domestic codification of the ECHR is the passage of the Human Rights Act in 1998, which essentially enshrines the majority of the provisions of the ECHR, but within the domestic jurisdiction of the United Kingdom, such that UK courts can now adjudicate on issues pertaining to the ECHR within the domestic jurisdictions of those particular courts and judicial systems.